Hello everyone, welcome to JIB Prep. In today's class, we'll discuss about unit number 29, important laws relating to recovery of dues. So in this particular unit, we'll understand about Recovery of Debt and Bankruptcy Act. So earlier it was Recovery of Debts due to Banks and Financial Institution Act, and in 2019, its name was changed to Recovery of Debts and Bankruptcy Act. Then we'll move forward to SARFAESI Act, IBC Act, Legal Service Authority Act, Law of Limitation. In the end, we'll do our practice questions and we'll wind up this session. So let's begin. Recovery, we all know that recovery of money is not always smooth for the banks. They need to explore legal avenues. They need to knock the doors of the court. And for this very purpose, going to a civil court is not always an easy task. And that's why there are certain enactments which Parliament provided for the easy recovery, and we'll discuss them one by one. So we'll start with Recovery of Debts and Bankruptcy Act. So recovery through civil courts was actually a major hurdle. Many assets, huge assets, were blocked as unproductive assets, and the process of recovery required a considerable time. And due to this, the Parliament passed an enactment which was known as Recovery of Debts due to Bank and Financial Institution Act. It was passed in 1993, and it enacted DRTs, Debt Recovery Tribunals. So the bank and the financial institution need not to go to the civil court for the recovery. They can approach debt recovery tribunals for speedy recovery, a faster recovery. And in 2019, the name of the act was changed to Recovery of Debts and Bankruptcy Act. So in this particular act was challenged by Delhi High Court Bar Association before the Honorable Delhi High Court. The Delhi High Court decided that this act is unconstitutional and it hit Article 14, and hence this act is void. An appeal was preferred to the Supreme Court. The Honorable Supreme Court held that this act is constitutionally valid. It gave the green light to Recovery of Debt and Bankruptcy Act. The question was referred to the Supreme Court regarding the applicability of this act to cooperative banks. So it was decided that debt recovery tribunals is not applicable to dues of cooperative banks since they have a recovery mechanism and it is working fine. It is working satisfactorily. However, it is applicable to multi-state cooperative banks. The extent of this act is whole of India, meaning to say this act is applicable to whole of India, including Jammu and Kashmir. And this act was made applicable from 24th of June 1993. Though DRTs are established progressively across the country. So through DRTs, this act is made applicable. Now, what is the qualifying amount? Meaning to say, how much amount is due before a bank can knock the doors of DRT? So, the qualifying amount is 20 lakh rupees or more. This amount can be in consortium or by the bank alone. Meaning to say, if bank A gave 10 lakh rupees and bank B gave another 11 lakh rupees, so this qualifying amount is there. So, sum up is 21 lakhs. And as consortium, the banks can approach the debt recovery tribunal. Now let's understand some important definitions. Bank. So what is a bank? Bank means a banking company, uh, and it includes corresponding bank, state bank, regional rural banks, multi-state cooperative banks. Debt. What is a debt? Debt means any liability which is due from any person by a bank or a financial institution, and this includes consortiums of banks and financial institutions as well, whether it is secured or whether it is unsecured, whether it is under a decree or a arbitration. So it is a debt. So as per this definition, debt means any liability which is inclusive of interest, any liability inclusive of interest, not only the principal amount but interest also, whether it is secured or unsecured, doesn't matter. Any liability towards the debt securities which are unpaid, whether in full or in part, after a notice of 90 days. Keep that in mind. After a notice of 90 days, any liability under a decree of the or order of any civil court or arbitration or otherwise, or any liability under a mortgage or a subsisting or legal recovery. Financial institution. Financial institution basically means a public institution and an ARC, Asset Reconstruction Company, which has obtained a certificate of registration under SARFAESI Act, Securitization and Reconstruction of Financial Asset and Enforcement of Security Interest Act, SARFAESI in short. It also includes a debenture trustee which is registered with the board and appointed for secure debt securities and any other institution which the central government has notified. So it is a financial institution. What constitutes a debt? It is quite important for us to understand what is a debt, and it has been interpreted by different courts in different case laws. So in GV Films versus UTI, so this particular case belongs to the year 2000. So in this case, it was held by the Madras High Court that the payment made by a bank by mistake is a debt. So if a bank made a payment to someone by mistake, so this payment is a debt. Person has to repay it. In State Bank of India versus SS Engineering Corporation, it was held that money overdrawn from a bank account without any overdraft facility is a debt, and it can be recoverable under Debt Recovery Tribunal Act. United Bank of India versus DRT. It is DRT. Uh, in this particular case was before the Honorable Supreme Court. So it was held that if a bank has alleged in the suit that the amount were due from the respondent as a liability of the respondent, and if the liability has actually arisen during the course of business activity and the same is still there, the same is still subsisting, then it is sufficient to bring that amount under the definition of the debt, and it is recoverable under DRT. However, in case of Bank of India versus Vijay Ram Nikolal, it was held that if an employee commits a fraud or misappropriation of money, then this amount is not debt. So you cannot say that if an employee has committed fraud or misappropriation of money, so you cannot term this amount as debt. Establishment, jurisdiction and authority of tribunal. When we say tribunal, we are meaning to say debt recovery tribunal. So there is DRT, Debt Recovery Tribunal, and there is DRAT, Debt Recovery Appellate Tribunal, and we understand one by one. So, what is DRT? DRT is constituted under this Recovery of Debt and Bankruptcy Act. This is the first place where the banks approach that we have to recover this certain amount of money from these borrowers. Please help us. So, this is the first place, and if they are aggrieved with the order of DRT, they have the option to appeal to some authority, and this authority is known as DRAT, Debt Recovery Appellate Tribunal. So who established DRT? It is the central government. This DRT is made up of only one person called presiding officer. So remember this name, presiding officer. This tribunal DRT, it is made only of this person. Now, what is the term of this office and who is qualified to become a presiding officer? So, a person is qualified for appointment as presiding officer if he is or has been, or even if he is qualified to be appointed as district judge. So, either he was a former district judge, he is a current district judge, or he is eligible to become a district judge, then he can be appointed as a presiding officer. The term is 5 years or until the age of 65 years, whichever is earlier. Meaning to say, if Mr. A is appointed as a presiding officer and he is of 62 years of age, then as soon as he attains the 65 years of age, he will vacate his office. So, whichever is earlier. So, if he is 58 years of age, then he will serve the office for a term of 5 years. Okay. Now, let's move on to DR80. Now, again, the central government has the powers to establish the appellate tribunals known as debt recovery appellate tribunals, and the central government is responsible to specify the areas within which the appellate tribunal may exercise its jurisdiction. Again, like similar to DRT, DRAT is also constituted of only one person, and this person is known as chairperson. Now, the qualifications are quite different for becoming a chairperson because DRAT holds a higher position than DRT. For example, you can understand DRT as an equivalent of civil court and DRAT as an equivalent of high court. So, for becoming the chairperson of DRAT, the person is qualified for the appointment of chairperson if he has been, meaning to say, is a former high court judge, or he is a high court judge, or he is qualified to become a high court judge, or he has been a member of Indian legal service and has held the post in grade 1 of that service for at least 3 years, or he is uh, he has held the office of presiding officer of DRT for at least 3 years. The term of office is 5 years or until the age of 70 years. Why? Because former DRT presiding officers are also eligible to become the chairperson of DRAT. Jurisdiction and authority of tribunals. So, a tribunal, a DRT, has a jurisdiction and power and authority to entertain the applications from the bank and financial institution for recovery of debts. Also, they can entertain applications under Part 3 of the Insolvency and Bankruptcy Code. DRAT, on the other hand, they handles the appeal uh, from the orders against DRT and order against Part 3 of the IBC. Now, the chairperson of DRAT, they enjoy the general power of superintendence, the general power of control over the tribunals. So they can basically transfer any application from any presiding officer within his jurisdiction, or they can direct the tribunal to furnish periodical information relating to pending case. They can convene meetings and they can submit recommendations to the central government for action against any presiding officer for misbehavior or incapacity. Bar of jurisdiction of civil courts. So basically, after the constitution of DRTs, debt recovery tribunals, no civil court has any jurisdiction or power or authority to deal with recovery cases. Now, recovery cases of what? Where the qualifying amount is 20 lakhs or more. So, no civil court has the authority to entertain any case with recovery of 20 lakhs and above pertaining to dues to bank and financial institution. Now, again, we have to keep this in mind that this is not applicable to high courts or Supreme Court, which are exercising their jurisdiction under Article 226 or 227. All right. Now, let's move on to procedure of tribunal. So let's understand the procedure of filing application with DRT, their disposal, recovery of dues. So first of all, for initiating recovery process, the starting point is giving notice to the borrower that we are filing an application with DRT. Once the notice is provided, we file an application to debt recovery tribunal. Of course, the provisions of Limitation Act they apply. Let's first understand what is a Limitation Act, what purpose does it serve. So, in order to bring a case, bring a suit, bring an appeal, bring an application before any court or the tribunal, there is a particular time limit. So you cannot sleep over your rights. So for example, if the limitation period is 3 years, so you cannot knock the doors of the tribunal or the court after 5 years or say after 4 years. So in 2010, if the cause of action has arise, so you have to file the case within these 3 years. Now, you cannot wake up from your sleep and approach the court in 2014 or 2015 that your lordship, we were not able to proceed with this application because we were not aware or something of that sort. So, the Limitation Act actually prevents the banks or the financial institutions to bring their cases to the court. I hope this is clear to you. Now, the qualifying amount should be there. So, the amount due should be 20 lakhs or the more. The content of the application should be complete. The details should be provided to the borrower. The details should be provided to the borrower, the guarantor, the credit facilities, the outstanding and the other claims should be there. So, the content and jurisdiction have to be kept in mind. The application should include the prayer, the remedies, the interim reliefs, and with now electronic facility is there, so application statements they can be filed electronically. The jurisdiction have to be kept in mind that the application can be filed with the tribunal, with the DRT, with which has the jurisdiction to entertain the application. You cannot randomly submit your application to any debt recovery tribunal. The debt recovery tribunal again has a jurisdiction, and this jurisdiction is how does it is determined. So the branch or any office of the bank, the financial institution is maintaining account in which debt claim is outstanding, or the defendant, or where there are more than one defendants, any defendant at the time of making the application, he or she actually resides or voluntarily resides or carry on the business or personal works for the gain within the jurisdiction of that tribunal, and the cause of action wholly or in part arises sorry arises within the jurisdiction of that debt recovery tribunal. Now, other banks can also join the application. So, where a bank or financial institution has filed the application before the tribunal, and if for the same person another bank has to recover any debt, then the later bank can join this filed application at any stage, but before the final orders have been passed. Application requirement. So every application before the tribunal shall be in the prescribed format, and it should be accompanied with the prescribed documents along with the fees and the evidence. Tribunal process. So once the application has been received, the tribunal issues the summons. Basically, it calls out the defendants uh, against whom the application has been filed with a direction that they are required to show cause within 30 days as to why the relief rate uh, should not be granted. So basically, why should not we take action against you? Why should not we give the relief to the bank? And they direct the defendant to disclose the particulars of the property or the assets other than the properties or assets which are offered as securities to the debt, meaning to say, we need to know what assets or properties you have apart from the secured assets. Okay, and they restrain the defendant from dealing or disposing such assets on the properties which are disclosed pending the hearing. and the disposals. And the defendant must file a written statement. Written statement meaning say defendant has to file his or her reply within 30 days, including set of claims. So if they have any claims against the bank or the financial institution, they should disclose it in their written statement. So defendant has certain rights. So set of claims are there, and then there are counter claims. So the defendant has any claim legally recoverable from the applicant, meaning to say the bank and or the financial institution, and they wishes to set off. So the applicant's demand with the certain sum of money must be set off with uh, they must be set off with the claims of defendant. So it should be filed in the written statement, or if they have any counter claim against the applicant, who is the applicant, the bank or the financial institution. So if defendant has a counter claim, they can also set up a counter claim for any right or claim in respect of cause of action, and this also have to be disclosed in their written statement. Securities and attachments. So if the tribunal at any stage or on the application of the applicant or along with the sorry, along with the particulars of property to be attached an estimated value, and they satisfied that defendant has an intent to obstruct the uh, orders or delay the orders or frustrate the execution of the orders. Now, if that is the purpose, then the tribunal can ask for the recovery or the tribunal can attach the property. So basically, you cannot sell the property, and if defendant fails to show cause as why he should not furnish security or fails to furnish security, then the tribunal may pass attachment orders. For attachment of property, the tribunal can pass a conditional attachment order of the whole or the part of the property. And in case of disobedience or breach by the defendant, then the person can be detained in civil prison for a term not exceeding 3 months. So, civil imprisonment can be ordered by the debt recovery tribunal, and tribunal can appoint, if they find it just and convenient, they may appoint a receiver of any property. They can remove any person from the custody or the possession of the property. We can give the possession or the custody to the person who is appointed as receiver, and they can confer powers to the receiver in respect of the property given in his possession for bringing the suit or to defend the suit, and they can also appoint a commissioner for preparation of inventory of the properties of the defendant, basically, or for the sale purpose. Interim final payment orders. So the tribunal may, after giving the opportunity to the both sides, can pass an order um, to the applicant and the defendant. So the order can be interim, meaning to say it is a part order, or the final payment orders can be passed. Recovery certificate. The presiding officer shall issue a certificate of recovery along with the final order for payment of debt along with the interest under his signature. Any recovery certificate issued by this presiding officer, this is equivalent to a decree of court. And when the property under the certificate of recovery is situated in jurisdiction of more than one tribunal, so the issuing tribunal will send copies to the tribunal having the jurisdiction, and if the if the receiving, if the receiving tribunal finds that it has no jurisdiction, it shall return the certificate back to the issuing tribunal. And as a sale, the sale proceeds of such company, they will be distributed among the secured creditor, and the surplus is paid to the company if the defendant is the company. affidavit as evidence. So DRT can consider that any fact may be proven by the affidavit, and once affidavit is submitted, it will allow cross examination of the witness only if the tribunal is of the opinion that it is necessary to do so, because they have to uh, proceed with the application in a speedy manner. So they have a time limit for disposal. So the time limit is 180 days. And what happens if a person or the company is aggrieved by the order of tribunal? So they have the right to approach DRAT. So they can file an appeal to appellate tribunal DRAT, but the appeal must be filed within 30 days from the order, and there are certain conditions that if a person or the company has to file an appeal, they have to deposit at least 50% of the amount due as per the order. This amount can be reduced to 25%, not less than that. So the tribunal, the appellate tribunal can reduce the amount to be deposited, but again, it should not be less than 25%. And after hearing both the parties, the appellate tribunal can pass the orders. They can modify the orders. They can set aside the orders, and the appellate tribunal shall dispose of this appeal. They will try their best to dispose of this appeal within 6 months of the receipt. So they shall attempt the appeal to be disposed of within 6 months from the date of receipt. Recovery process and modes. So there's a recovery procedure. So on the receipt of copy of recovery certificate, a recovery officer is appointed, and that recovery officer has to proceed to recover the specific amount by attaching or selling the properties of the defendant. The property can be movable or immovable. So any of the property can be attached and can be sold in order to recover the amount. We can take in possession of the property. We can arrest the defendant if he is obstructing with the procedure. Uh, we can send for the detention in prison, but again, the provision of arrest should be used in line with the decision. So George Verghese was the case. Let me write it down for you. George Verghese versus Bank of Cochin. So the guidelines issued by the Supreme Court in this particular case have to be kept in mind before arresting, or detaining the defendant in prison. Objection to recovery certificate. So the defendant is debarred from raising any dispute before the recovery officer, again for the about the correctness of the amount. So the recovery officer cannot entertain any objection. All right. RO, recovery officer, they will not entertain any request. They will not entertain any objection. So it is the presiding officer of the tribunal who issues the recovery certificate, and he is the person who is authorized to withdraw the certificate, to correct the certificate, to see if there is any arithmetic mistake. So it is the presiding officer of the tribunal who will receive the objections to the recovery certificate, and not the recovery officer. Say amendment of recovery certificate. So even though a certificate has been issued to the recovery officer, the presiding officer may grant time for the payment of the amount, provided defendant pays a down payment of 25% at least of whatever is mentioned in the recovery certificate, and again they will give an unconditional undertaking to pay the balance within a reasonable time. Again, this reasonable time has to be acceptable to both the bank or the financial institution and the defendant. and if such time is granted, the recovery officer has to stay the proceeding until that time period is expired. Payment under recovery proceedings. So, if after issue of recovery certificate, defendant makes any payment, then the presiding officer has to keep the recovery officer informed. As simple as that. Execution of recovery certificate. So, while execution of recovery certificate, the recovery officer can require any person against whom the recovery certificate is issued to declare on affidavit about the particulars of his assets, like income tax area. So, the recovery officer has the power to recover the amount in a similar fashion as laid down under the Income Tax Act. So, these payments will be treated in a similar fashion as they are income tax areas. Then there are other modes of recovery, like from a debtor of defendant. Mean say if any amount is due from any person to the defendant. For example, if A is defendant and A has to recover money from B, then the recovery officer will ask B to pay the amount to the recovery officer and not to the defendant. However, this provision, exemption of the amount from attachment as provided in CPC, it applies from a bank or financial institution. So, when such notice is issued to a bank or any financial institution, it shall be not be necessary to produce any passbook for any purpose for payment. Provision of DRT has overriding effect for any such requirements. Property under notice. So, when such notice is issued in relation to any property, when any claim made against such property is void. So, if you make any claim against the property uh, for which the notice has been issued, then those claims will not be entertained, they will be void. But again, if third persons have vested rights in those property, they can raise their claims, and we'll discuss about it, don't worry. From holders of defendant's property. So these provisions also apply to any person who is holding any money for on or account of the defendant. So in case there is a joint holding, then the equal share of the joint holder is they are presumed that it belongs to defendant. For example, A is defendant and A holds a joint property with B, and this property say is of 1 crore, then it will be presumed that A has a share of 50 lakhs in this property and this amount can be recovered. Third person is not liable. So, if any person receiving the notice from recovery officer is not liable to pay or is not holding anything on behalf of the defendant or for the defendant, then they can object to the such notice and they will not be liable. So, if third person is innocent, uh, acting in good faith, then this third person will not be liable. From a court holding money, so if a court is holding money belonging to defendant, then the recovery officer may apply to the court that uh, the court will pay the money to the recovery officer. Payment by third person. So if a person pays to recovery officer as per the notice served, then he is discharged from the liability. Now here if B pays to recovery officer, then B is discharged from his liability. So this third person, if he or she makes the payment, then they will be discharged, and if they fail to pay, then the recovery officer may serve them with the notice, and they will be treated like the defendant. They will be deemed to be the defendant. Appeal against order of recovery officer. So when recovery officer attaches the property, sells the property, and it is possible that third party have any interest in such property, and that interest gets affected. So they can file an appeal to the DRT within 30 days. Uh, and thereafter the DRT may allow the appeal and may set aside they can modify the order, they can set aside the order, or they can either confirm the order. Power of tribunal and appellate tribunal. So they have the power to lay down their own procedure. They are not bound by CPC, Civil Procedure Code. So they are not bound by it. They are guided by principles of natural justice. And hence they have their power to lay down their own procedure. How will they function? Powers of civil code. So the DRT and DRAT, for the purpose of discharging their function, they have the power similar to the power which are vested to a civil court. Transfer of pending appeals. Keep that in mind that limitation period also applies. So it applies to DRT and DRAT. Transfer of pending appeals. So if a specific appeal is there, there is a case and application has been filed for the transfer. So the tribunal DRAT has the power to transfer that appeal from one tribunal to another tribunal. Chairperson, presiding officer, staff of appellate tribunal and tribunal. So they are deemed to be public servant for the purpose of IPC, now BNS. So they will be deemed to be public servant, whether chairperson, presiding officer, staff of appellate tribunal or tribunal, they all are deemed as public servant. Overriding effect of the act. So the provision of this act, they have overriding effect when there is inconsistency with any law, or if any instrument is there and there is any inconsistency, then this act will override, meaning to say it will surpass that other law and this particular act will prevail. Uh, in Allahabad versus Canara Bank, viral filaments versus Inducent Bank. So in all these cases, the Supreme Court held that this act supersedes, overrides the Companies Act. DRT Act, again, it is exclusive for debt recovery, and proceedings cannot be stayed or transferred to a company court. So the adjudication is exclusive. They have the jurisdiction of civil courts, and so sorry, the jurisdiction is exclusive, and the jurisdiction of civil courts and company courts, they are they are not applicable with respect to these recovery cases. So DRT proceedings cannot be stayed by a company court, nor proceedings can be transferred to a company's court. All right. And when no winding up order has been passed against the company, the distribution of money realized under DRT uh, among banks, financial institutions, they are to be prioritized subject to the principle of CPC and principle of natural justice. When winding up of proceedings are pending in company court, then the distribution of money under DRT among banks and other secured creditors is there. But the employees whose dues are there with the company, they will also be treated as secured creditors. Uh, and the distribution between those secured creditors and the workmen should be on the pari passu basis, on the equal basis. Doctrine of election. So basically, the banks and financial institution has the right uh, to either choose DRT or the SARFACI Act. So banks and financial institution can withdraw their DRT application to pursue actions under SARFACI Act. Now the question is whether we have to withdraw the application from DRT, then only we can proceed under SARFAESI Act. So question arises before the Honorable Supreme Court in Messrs Travancore versus Union of India in 2006, and Supreme Court decided various points. So the Supreme Court observed that for election there should be three elements. Number one, there should be existence of two or more remedies. Number two, now the remedies have inconsistencies, so there is inconsistency between the remedies. And number third, you have choice of choosing any one of the remedies. So if any one of the element is not there, then the doctrine of election is not applicable. So there is no inconsistency between the remedies, then also the doctrine of election does not apply. Now, SARFAESI is enacted to enforce the interest in financial assets which belongs to the bank or the financial institutions, and the DRT is tribunal which is created by statute. It has no inherent power which exists in civil court. Uh, so the controversy whether the doctrine of election is there, so whether you have to withdraw the DRT application in order to proceed with SARFAESI Act. So it is not there because there is no inconsistency exists between DRT and SARFAESI remedies, and hence doctrine of election cannot be then the doctrine of election is not present at all. So these three remedies, sorry, these three elements should be present in order uh, to say that doctrine of election applies. Since there is no inconsistency between the remedies, uh, doctrine of election is not there, and hence withdrawal of DRT application is not a precondition for SARFAESI Act. Now let's move on to SARFAESI Act. Let's introduce it. SARFAESI Act. So this act was actually a landmark enactment for banks and financial institutions. So it introduced major changes in legal framework for the recovery. It streamlines the functions of reconstruction companies for dealing with financial assets of banks and the financial institutions. So this particular act empowers the banks and the financial institutions to enforce their securities uh, even without the intervention of the court, uh, either court or the DRT. So the power given by this act, it has an overriding effect on other laws in this aspect. The power are also over and above other remedies. So other remedies are available, and these powers are over and above these other remedies by filing appropriate proceedings either in the civil court or the DRT. Now let's understand the fundamental aspects of SARFAESI. So this particular act has brought a legal framework for securitization of financial assets, reconstruction of financial assets, power to enforce securities for recovery of dues to banks and the financial institutions, and the provisions for reservation, for provisions for registration of transaction of securitization, reconstruction, and creation of the security assets. The extent similar to DRT Act, it is applicable on whole of India. Now, the applicability of this act is up to the banks, to the financial institutions, ARCs, debenture trustees, and other notified companies by the central government. Uh, Securities interest. So, the provisions relating to the enforcement of security interest, it applies to cases in which security interests are created by for due repayment. So, the act has presupposed that there is an obligation. So, number one, there must be an obligation, and it is presumed, it is presupposed that there is an obligation on the part of the borrower to repay the loan, and if they are unable to repay the loan, then the securities which are available to the banks or the financial institutions, they can sell these securities to recover their amount. There is a qualifying amount in order for the applicability of this act. There is a qualifying amount of 1 lakh rupees, and the amount due should be more than 20% of the principal amount and interest. And if these conditions are met, then SARFAESI Act is applicable, else the SARFAESI Act is not applicable. So the qualifying amount we have just discussed it. There are certain exclusions to the act. So this act is not applicable on agricultural land. It is not applicable on pledge which are created under uh, the pledge which are created on movable property. So this particular act is not applicable on lien of any goods or money created under Indian Contract Act, pledge of movable property, creation of securities interest in any vessel. It is not applicable on vessel, on the aircraft. If the security, if the security interest for repayment basically is not exceeding 1 lakh rupees, or 20% amount is not due, then this act is not applicable, and it is not applicable over agricultural lands as well. If any property is not liable for attachment or sale of CPC, then this act is not applicable on those securities as well. So these are certain exclusions from the SARFAESI Act. So SARFAESI Act particularly is not applicable in those scenarios. So if there is a lien, there is a pledge, created on vessel, aircraft, agricultural land, so on and so forth. Priority. So as per the amendments of SARFAESI Act, secured creditors have a priority over the claims over uh, with, when compared to unsecured creditors. So secured creditors have the priority over and above all the claims, including any debt, revenue, tax, or cess which is due or payable to the government or local authority. The constitutional validity again was challenged, and it was held that this act is constitutionally valid in Mardia Chemicals versus Union of India. Only one provision was made unconstitutional. Uh, the provision was that the borrower can file an appeal to DRT only after depositing 75% of the amount claimed by the lender. So the Supreme Court declared this unreasonable, arbitrary, and this was amended to 50%. Now let's understand some important definitions. So asset reconstruction is basically acquisition by any ARC, any asset reconstruction company, of the right or the interest of bank or the financial institution in a financial assistance for realization of such financial assistance. So in simple words, it is nothing but takeover of the loans or advance. Asset reconstruction is nothing but takeover of the loans or advances from bank or financial institution, and the purpose is the recovery. Hypothecation is basically a charge. We have studied hypothecation, if you remember. Hypothecation is nothing but a charge which is created on movable properties. It can be future, it can be existing, and it is created in favor of secured creditor. In hypothecation, there is no delivery of possession. Delivery of possession is a key feature of which charge. When we say of movable property, the possession is given in pledge and not in hypothecation. So hypothecation is a charge on movable property. Movable property can be existing or the future, and it is created by the borrower. in whose favor it is created in favor of secured creditor, and when it is created, there is no delivery of possession to the creditor, and it also includes floating charges. Obliger. Obliger means a person who is liable for the payment, to pay a financial asset or to discharge any obligation in respect of financial asset, whether existing, future, conditional or contingent. So it is a person who is liable to originator. So who is an originator? Originator is the owner of the financial asset which is acquired by ARC for the purpose of securitization or reconstruction. In simple words, originator is no one but the bank. So obliger is the borrower, and borrower is liable to the bank or the financial institution. So we have understood originator. Securitization. Securitization means acquisition of financial asset by ARC from any originator. Originator means the bank or the financial institution, whether by raising of funds by ARC from qualified buyers by issue of security receipts representing an undivided interest in such financial assets or otherwise. So basically, this is a process where non-liquidated financial assets are convertible into marketable securities. So it is a securitization is nothing but a process where non-liquidated financial assets, they are converted into marketable securities, that is security receipt, and these marketable securities are then issued to the investors. So the process is known as securitization. ARC, Asset Reconstruction Company. So a company should obtain a certificate from RBI in order to be called an ARC, an Asset Reconstruction Company. And ARC should maintain NOF, net owned funds, of 300 crores. Earlier it was 100 crores, but this limit was raised to 300 crores. So they can raise funds through issuance of security receipts. So they can raise money for their acquisition by issue of security receipt under schemes which are formulated by ARC themselves. And there are certain conditions for registration as ARC, that they should have not incurred any losses in last 3 years, last three preceding financial years. The directors have the experience. No director is convicted for any offense. They should make adequate arrangements for realization of financial assets which are required, and they shall be able to pay the periodic returns or redeem the respective due dates. The investments which are made by the qualified buyers, and they should comply with the norms of RBI. Acquisition of rights of interest in financial assets. So an ARC must have a board approved financial asset acquisition policy. The ARC can acquire the financial assets of any bank or financial institution in two ways. Number one, by issuing a debenture, a bond for the security, and number two, by entering into an agreement with the bank or the financial institution. So they can acquire by issuing the debentures or bonds, or they by entering into agreement with the banks or the financial institution. A securitization transaction, it involves two stages. And yes, these agreements are to be under this SARFAESI Act, they are exempt from the stamp duty. So if a question comes whether the agreements are liable for the duty, yes or no, so you will have to mark no. Now, securitization transaction, it involves two stages. Number one, the acquisition of financial assets with which have the undivided interest, and second, the issue of the security receipt in favor of investors. And what is the purpose? The purpose is very simple: to raise the money from investors by issuing these securities. ARC becomes the lender. So if the bank or financial institution is the lender and the right has been acquired, so that financial asset has been acquired by ARC, then this ARC is deemed to be the lender. As simple as that. So if bank is the lender and this financial asset is acquired by ARC, then automatically this ARC becomes the lender. And if there is any liability or commitment to be discharged from the side of bank, those commitments or the liabilities, they will not be passed. Only the rights will be passed from banks to ARCs. No liability of ARC, no liability of the bank will be passed to ARCs. So if there are any pending cases, pending appeals or proceedings of whatever nature which are related to the asset, and it is pending by the bank or against the bank, it will not get discontinued. Okay, they will continue uh, even if the financial asset has been acquired by the ARC. There are certain key documents which are connected with securitization transaction. We need to understand them. Number one is offer document. So an ARC which intends to issue a security receipt, they shall make the prescribed disclosures. By and large, the full details and particulars about the financial asset should be given. The loan details of the bank should be given. Who's the trustee? All of these details are to be there in the offer document. Debentures. A debenture is issued to the bank or the financial institution for the payment of consideration for the acquisition of financial asset. So what ARC does? ARC acquires that asset. ARC uses securitization process. Uh, ARC will redeem the money. They will collect the money, and this money will be passed on to the banks and the financial institutions. And for this similar purpose, the debentures is to be issued to the banks and the financial institutions. And the rate of interest which is offered in the debentures, they cannot be less than 1.5% above the bank rate. So this interest cannot be less than this. Obviously, if they want to give more, they can give more interest rate to the debentures. And the period of re- redemption, it should be less than 6 years. It should not exceed 6 years. An agreement should be there, and security receipts, it should be in favor of the investors. So these are the key documents in securitization. Notice to obliger and discharge of obligation. So when the bank or financial institutions uh, decides that the asset is now been acquired by ARC, a notice has to be given of such acquisition to the borrower and the concerned registering authority. And giving this registration, giving this notice is optional and it is not compulsory under this act. So it is not essential to give the notice. Issue of security receipts and raising funds by ARC. So an ARC, an asset reconstruction company, may after acquisition of any financial asset, they can offer security receipts to the qualified buyers or such category of investors including non-institutional investors. So this security receipts, they can be issued to qualified buyers or non institutional investors, but they cannot be issued to public. Individuals are barred from making any investment in ARC, and these security receipts will not be issued to the general public for subscription. Condition for the issue. So for ARC to raise the fund from qualified buyers, certain conditions are to be met, like separate scheme should be formulated for acquisition. Now scheme wise and asset wise distinct account should be maintained. Realization of financial asset should be held separately, and in case there is no realization and repayment, uh, there is no realization, repayment for the QBs, the qualified buyers, that in holding not less than 75% of the total value of the security receipt issued, they are entitled to call a meeting, uh, and they are entitled to pass a resolution. So there's no repayment. The qualified buyers holding greater than or equal to 75% of the security receipt, they can convene their meeting and pass a resolution which is binding on the asset reconstruction company. Separate trust. So when separate schemes are made and funds are raised, the provisions of SARFAC, they do not directly provide for setting up trust for each scheme. However, for legal effect, there should be a separate trust. Uh, in eventuality of liquidation of ARC, the money does not pass on to liquidators, and the beneficiaries get the money on priority, uh, and their distinctiveness. Registration exemptions. So registration of security receipt is required if it is creating, declaring, assigning, limiting, or extinguishing any right in an immovable property. So in that case, registration is mandatory, it is required. Until unless it is not happening, no registration is required. But if any right is created, assigned, liquidated in immovable property, then the registration is required. There are certain other functions of asset reconstruction company, like they act as agent for the bank, they act as managers for the secured asset, they act as receivers if they are appointed by the courts or the tribunals. Resolution of dispute. So if there is any dispute between the bank or the financial institution, financial institution and the ARC, uh, that dispute will be resolved by arbitration, as provided as per the provisions for Arbitration and Reconciliation Act of 1996. The provisions of mandatory arbitration and conciliation, they are not applicable to the dispute bar against the borrower, but where the dispute is between ARC and banks, financial institution, or the qualified buyers, then they will be resolved via conciliation or arbitration. National Asset Reconstruction Company. So it has been set up with an initiative to clean up the stretched asset where the exposure is greater than 500 crores or above in the banking system. They offers adaptable acquisition structures comprising of a mix of cash and security receipts to the selling banks and the financial institutions. Uh, Mainly the focus is on aggregating stressed assets for effective resolution. So the acquisition process is administered by the financial asset acquisition policy, which are framed under the guidelines for ARC, and the stress is for effective resolution of these stressed assets. Measures of asset reconstruction. Now let's understand these measures. Cognizance of other laws. So the powers which are provided under SARFAC Act, they are subject to the provisions of other existing laws, meaning to say power to take various measures for asset reconstruction which are contained in SARFAC. They are provided without any prejudice to any other law. All right. Secondly, permissible measures for asset reconstruction company. So, number one is to change or take over the management of whom? The business of the borrower, right? It is the business of the borrower. So, a borrower unit which has been classified as NPA, but it is still functioning. So, it can be treated differently by the banks because it is still in function. Now, this business might provide certain revenues to the bank, to the financial institution, and hence if they find that the management was incompetent, they will take over the management, and this power can be exercised even when there is no default. Keep that in mind. So if there's the management is found to be incompetent, then uh, the asset reconstruction uh, companies can take over the management, sale or lease of business. So asset reconstruction companies are currently not permitted to resort this measure until RBI provides guidelines. So you cannot sell or lease off the business. Rescheduling of debt payment. So every asset construction company should have its policy, which is approved by the board of directors, laying down broad parameters for where the debt can be rescheduled or not. And in case there is a certain exposure of ARC to a borrower in respect of resolution plan, then the ARC should also sign intercreditor agreement, in short ICA. Intercreditor agreement should be signed. uh, Enforcement of security interest. So the consent of secured debtors holding not less than 60% of the amount outstanding to a borrower, it should be obtained for this purpose, for the enforcement of security interest. Settlement of dues. So every ARC shall frame a policy laying down the broad parameters for settlement of debts due to the borrowers. Taking possession of secured assets. So it should be done in accordance with the provision of SARFAESI Act. Conversion of debt to equity. So every ARC shall have its policy laying down the parameters in uh, where the debt can be converted into equity, meaning to say the shares of the borrower company. Enforcement of security interest. So under SARFAESI Act, secured creditor can enforce the security interest. Just a second. Yes. So let's understand general condition first. So under SARFAESI, secured creditors have this right to enforce the security interest created in their favor without the intervention of any court or the tribunal. And this power has an overriding effect with respect to Transfer of Property Act. Secondly, the borrower must be classified as non-performing assets. So the secured creditor must provide a notice to the borrower who has been defaulted in making the payment and who is classified as non-performing asset, and this notice has to be provided within 60 days. Debenture trustee, they may also enforce the security. So this is the notice that we were talking about. We'll understand it again. So the notice has to be provided within 60 days uh, to the borrower, stating that you should discharge your liabilities in full, and this notice should include the amount payable to the financial institution, if there is any secured interest, its details, uh, when the default has occurred, what is the overdue period, what is the date which has been classified as non-performing assets. um, the documents should be provided, securities provided, and the executed document should be there. And the borrower cannot transfer property which has been mentioned in the notice. If he or she does it, then it will be a violation, and that would be a punishable offense. The notice should also highlight the consequences. The consequences can be legal, and the penalty which can be imposed on the secured, uh, which can be imposed by the secured debtors on the borrowers. Now let's understand Mardia chemical case. So this was the case where the constitutional validity was also challenged. We have just read about it. So there are certain guidelines which were laid down by the Supreme Court in this particular case, that the secured creditor must apply his mind to the objection which are raised by the borrower in response to the notice. Secondly, an internal mechanism should be there to consider the reply of the borrower. There may be some meaningful consideration in the objection raised, and their rejection should not be a ritual exercise. They should follow the actions. The reason for overriding the objection must be communicated to the borrower within 15 days, and the borrower cannot seek any injunction or any stay during this process. Now, let's understand creditors' right after default. So, if the borrower has defaulted, what are the rights of the creditor? Uh, so, if the borrower fails, creditor can take measure under SARFAESI Act to recover the dues without the intervention of the court. Borrower can stop transfer if dues and expenses are cleared before sale or transfer. So, if the dues are cleared by sale, then the borrower can stop proceedings under SARFAESI Act. If the sale has been postponed, then the creditor office can bid on behalf of the creditor. So, if there is a postponed sale, the creditors officer, they can bid on behalf of the creditor, and in case of there are multiple creditors, the action can be taken only by 60%, only by the creditors who are representing not less than 60% of the value. Appropriation of sale. So, where does this sale proceeds gets appropriated? Firstly, it goes towards the any cost, charges or expenses which are incidental towards the preservation, protection of the security, any insurance premium, those can be recoverable from the borrower. Secondly, the dues of the secured creditors are settled. And thirdly, if there is any surplus left, then it will goes to the borrower himself or the person who is entitled to with respect to rights and claim. So the cost has been settled, the dues has been settled, and if there is any surplus, it will goes to the borrower himself. There are certain special situations. So in case the borrower is a company and it is under a winding up process, then the dues payable to the workmen, they will be equivalent. Pari passu means on the equal footing. They will be on the equal footing with the secured creditors. If sale does not recover full dues, then the creditor have the right to approach the civil court or the DRT in accordance with the qualifying amount. So if 20 lakhs or more, DRT. If 20 lakhs is not, the condition is not met, then to the civil courts. And the creditor may also sell any pledged goods, or they can proceed against the guarantors uh, independent of secured asset. So if there's a secured asset, it doesn't matter. They can sell the secured asset and they can also proceed against the guarantor. Safeguards and authority. So the enforcement should be proper, it should be fair, and the authorized officer must be of chief manager level of a public sector bank or equivalent. The borrower cannot transfer any secured asset without the creditor consent. If he or she does it, then it is a punishable offense where the imprisonment can be of 1 year or fine or both. A procedure of for possession and sale. If it is a movable property, then where the possession of secured asset is to be taken by the secured creditor, it should be done in the presence of two witnesses. And a panchnama should be drawn in a prescribed format where the inventory of the property which is taken in the possession should be prepared and a copy is given to the borrower. Then the value is estimated and at what price we will sell it, it is there. So what is the estimate value or the reserve price, the price below which we will not sell. So it is a reserve price, it is fixed. Assets should be preserved and they should be insured until the sale has happened, so that if there is any damage, no loss uh, is incurred. If it is perishable, if the movable property is perishable or it is costly to maintain, then we'll try to sell it immediately will not wait to get it perished. There are certain sale methods like quotation, tender, auction. So will resort to the best method. Uh, will we can also include a combination of the methods. Then a notice is provided to the borrower. Uh, a notice of 30 days is provided. A certificate of sale is issued, which shall be a prima facie evidence of the title of the purchaser, and it should also be published in two leading newspapers. It should also be published in two leading newspapers, including the local vernacular language. So, notice in newspaper deemed to vacate office. Uh, so, the valuation of the property, it is the manner and effect of, sorry, takeover of management. So, a notice is provided. Okay, so we skipped one slide. Let's talk about first the procedure and possession of sale where it is immovable property. So, after movable property, if the security interest has been created in immovable property, then what should be the steps that we should follow? So, it serves as we serve a possession notice to the borrower. It should be affixed to the property and published in newspapers. We obtain the valuation and we fix the reserve price. In this case, also will provide a notice to the borrower. We can sell below the reserve price only if the borrower and the creditor consents, because it is the minimum price below which we will not sell. The purchaser obtained deposit 25% of the amount, and the balance should be paid within next 15 days. Maximum 3 months can be provided to the purchaser. On full payment, sale certificate is provided. Role of magistrate. So, for taking possession or control of the secured asset of or its sale or transfer, the secured creditor can take the help of Chief Metropolitan Magistrate, CMM for short, or DM, the district magistrate. For this purpose, a written request is submitted to the authorities, and on receiving such request, the CMM or the DM take the possession of the security and the documents thereafter. Now, let's talk about manner and effect of uh, management takeover. So, firstly, there should be a notice which is provided in newspaper. So, the notice is to be provided in two newspapers deemed to vacate office. So, on publication of such a notice, the director of the company um, are deemed that they have vacated their offices. Custody and control. So, all the property and effect of the business of the borrower, they are deemed to be in the custody of the appointed director or the administrator, and those appointed director and the administrators, they are uh, empowered to take any step, uh, necessary step into their custody or under their control. So, this is one and same. Effect of takeover in case of company. So, when the borrower is a company, the shareholders cannot lawfully appoint any person to be a director. This right is not provided to them no more. Resolution of shareholders can be effected only with the approval of the secured creditor, and no proceedings for the winding up or for the appointment of a receiver shall lie except with the consent. Post recovery. So, on realization of debt in full, the secured debtor shall restore the management of the business. Subsequent security interest. So, secured creditors and creditors holding order of attachment, they shall have priority over all subsequent security interests which have been created on the property, or by any transfer of sale, lease, assignment, license, or any other instrument. No compensation will be provided to the directors whatsoever for the loss of office. Uh, or for any premature termination of any contract, the remuneration will not be provided. Right of borrowers and others, right to prefer application to DRT. So if the borrower is not happy with the decision of DRT, if sorry, if any person, including the borrower, uh, they are not happy with the decisions, then the borrower has the right to prefer an application to DRT. This has to be done within 45 days. If they are aggrieved with the decision of the DRT, then they can prefer an appeal to the appellate tribunal within 30 days, and they have to deposit the amount 50%, which can be reduced to 25%. The DRT also in this particular case is required to dispose of this application within 60 days with a maximum period of 4 months. Right of borrow for compensation cost. So if DRT or the appellate tribunal holds the possession of secured asset it is not in accordance with the provision, they can direct the secured creditors to return the asset to the borrower, and the borrower is entitled for compensation as well as the cost which is determined by the tribunal. Central registry. So the central government has set up a central registry for registration of securitization, reconstruction and creation of security. So these are there are certain other acts as well for the registration, like Registration Act is there, Companies Act, Patent Act, Design Act, Motor Vehicle Act, etc. So the registration is in addition to the with these respective acts. So registration with the central registry, it is in addition to the respective registration which are done under the other acts like Registration Act, Companies Act, Patent Act, Design Act. So this is in addition to them. Modification of security interest should be registered with the central registry, and the central registry became operational on 31st of March 2011. So it functions under central government. And what is the central registry? It is CERC, the Central Registry of Securitization and Asset Reconstruction and Security Interest of India. In short, CERC. So it is the central registrar. Non-application of the provision we have already discussed in the exclusions. Let's understand the other aspects of SARFACI Act. So, good faith protection. The secured creditors and the officers, they are protected for their action which are taken in good faith. Offenses by the company. So, if company commits an offense, the company and every person who is at the time of the offense was committed was in charge, then he will be responsible to the company for the conduct of the business of the company, and they shall be guilty of the offense and liable, and they will be punished accordingly. No civil court jurisdiction is there. So the SARFACI has conferred jurisdiction to DRT or the appellate tribunal. Therefore, for any such matter where the empowerment and jurisdiction is to DRT or DRT, the jurisdiction of civil court is ousted, it is excluded. Overriding effect. So as we have seen that for particular uh, points, the SARFACI prevails over other conflicting laws, but uh, compliant acts, sorry, like Companies Act, SEBI Act, it is in addition to these acts, but not to but it does not override these acts. It is in addition to these compliant acts like Companies Act, SEBI Act, Recovery of Debt and Bankruptcy Act, etc. Limitation period for taking action. You must take action within 3 years from the cause of action, from the date when the cause of action arises. If you approach the court after these 3 years, your application will not be entertained. Introduction to Insolvency and Bankruptcy Code. So now let's understand this major code. So Insolvency and Bankruptcy Code, this is a landmark enactment. Prior to this, there are multiple overlying laws that govern various um, various facets of the corporate processes, insolvency processes. They are not comprehensive at all. So the IBC uh, is of major relief when it comes to insolvency and bankruptcy process in India. So it has essentially three sets of provisions. So the matters relating to insolvency and liquidation of corporate debtors. Number one, where the default amount is 1 crore rupees. Number two, of individuals, partnerships, and firms where the default amount is not less than 1000 rupees. And then the matters which are related to the Insolvency and Bankruptcy Board of India. So to whom the IBC applies? It applies, it covers the insolvency, liquidation, voluntary liquidation, bankruptcy of companies, LLPs, incorporated bodies, guarantors, partnership firms, individuals, personal guarantors to corporate debtors as well. So all of this is covered under IBC. Now let's understand four key terms: insolvency, bankruptcy, financial creditor, and operational debt. So these are basically operational creditor. So let's first understand insolvency. Insolvency is when a person or an organization is not able to meet its outstanding debt towards its lender. So it can be resolved by restructuring the debt or by writing it off, or if it is unresolved, it stays unresolved, then the assets can be sold to pay off the outstanding debt. Now, what people does it? They match the insolvency with bankruptcy. So they consider it as one and the same thing, but it is different. Bankruptcy is when a person voluntarily declares himself as insolvent. So bankruptcy is rather amicable than insolvency. When a person declares himself insolvent before the court of law, the court is responsible to liquidate the personal property. So in bankruptcy, it is the court that liquidates the personal assets of the person. So it provides a fresh lease of life to the insolvent. Financial creditors are the person who, or the organization who has given you a loan, a debt, or basically there's a financial contract. So there's an exchange of money. In operational debt, the claim is in respect to the provision of goods or services. So a workman, if the salary of a workman is not given, it is an operational debt. And if the money of a creditor is not given, then it is a financial debt. It is financial creditors. Let's understand certain key definitions. A charge is an interest or lien which is created on the property of or asset of any person or any of its undertaking, as the case may be. It also includes mortgage, corporate debtors. Corporate debtor means a corporate person who owes any money. So who's a corporate person? A corporate person is a company which is defined under the Companies Act, LLP which is defined under LLP Act, or any other person incorporated uh, for that time being in force. So it is a corporate person. Security interest. A security interest means any right, a title, interest, or a claim to the property which is created in favor of a secured creditor by transaction or by creating any charge. The charges which we have already discussed in our unit number 26, mortgage, hypothecation, assignment, pledge. So different types of charges can be used in order to create a security interest. Pillars of IBC. So there are four pillars, rather five pillars actually. So there are mainly five pillars: Insolvency and Bankruptcy Board of India, Insolvency Professional Agencies, Insolvency Professionals, Information Utilities, and Adjudicating Authorities. So these are the five key pillars of Insolvency and Bankruptcy Code. So let's understand one by one. Insolvency and Bankruptcy Board of India. So it was established on 1st October 2016, and it has regulatory oversight over insolvency professionals, insolvency professional agencies, and information utilities. So the Insolvency and Bankruptcy Board of India is responsible to write and enforce rules with regard to the processes, mainly corporate insolvency resolution, corporate liquidation, individual insolvency resolution, individual bankruptcy under IBC. So it writes and enforces these processes. The board composed of a chairperson, three members ex officio. They should not be below the rank of joint secretary from Ministry of Finance, Ministry of Corporate Affairs, and Ministry of Law. So one from Ministry of Finance, one from Ministry of Corporate Affairs, one from Ministry of Law. In total, three. One member should be nominated by RBI, and five other members, at least three, should be whole-time directors, which are nominated by the central government. The term of chairperson and the members, other than these official members, it is that of 5 years or 65 years of age. Now let's discuss about insolvency professional agencies. So before that, let's quickly understand the powers and functions of Insolvency and Bankruptcy Board of India as well. So the board shall register insolvency professional agencies, insolvency professionals, information utilities, and it renew and withdraw, suspend, cancel their registrations. Secondly, they can carry out the inspection investigation against insolvency professional agencies, insolvency professionals, information utilities. They can specify the standard of functioning, they can issue necessary guidelines, they can make regulation and guidelines on the matter related to insolvency and bankruptcy. Now let's understand insolvency professional agencies. So a person carrying on the business as insolvency professional agencies, they should enroll insolvency professionals as its members, and they provide a certificate of registration which is issued by the board. So these agencies basically regulate the activities of insolvency professionals. So they grant membership to the persons. They lay down the standard of professional which is conducted by insolvency professionals. They safeguard the rights, privileges, and interest of insolvency professionals, and they can suspend and cancel the membership of insolvency professionals. So insolvency professionals are the persons who assist in completion of insolvency resolution, liquidation, and bankruptcy proceedings, and they are governed by insolvency professional agencies. So basically, in any insolvency resolution, liquidation, and bankruptcy, the insolvency professionals, they can take actions like individual IRP, insolvency resolution process, or corporate IRP, or a fresh start of order, or individual bankruptcy process, or liquidation of corporate debtor firms. So these actions can be taken by insolvency professionals. Information utilities. So information utilities, they collect, collate, and authenticate the financial data, and finally disseminate the financial data. So they maintain electronic database on lenders and the terms of lending, so that delays can be eliminated, and the disputes uh, when a default arises can take place. So a person to carry on a business of information utilities, they shall obtain registration from whom? From the IBBI, the Insolvency Bankruptcy Board of India. So they provide the information utilities. They provide specified services, including core service to any person. If such person complies with the terms and conditions. So, any person who intends to submit financial information to information utilities or access the information, they shall they have to pay a specified fees and they submit the information. Adjudicating authorities. So, adjudicating authority is different for different entities. For corporate person, the adjudicating authority is National Company Law Tribunal, and appellate authority is National Company Law Appellate Tribunal. For individual and firms, it is DRT and DRAT. And for any appeals, appeals should be filed within 30 days before the appellate authority. And appeals to the Supreme Court can be filed if the question is on the question of law and not question of fact, and it should be filed within 45 days. The ground for appeal can be that the approved resolution plan is in contravention of the law. There is any material irregularity, the debts owed to operational creditors have not been provided, the resolution plan does not comply with the criteria which has been specified by the Insolvency and Bankruptcy Board of India. Now, civil courts don't have the jurisdiction here as well. Uh, the jurisdiction exclusively lies to NCLT or DRT, as the case may be, and where an application is not disposed of within the period which has been specified in the Insolvency Bankruptcy Code, then every reason has to be provided why there's a delay in disposing of the cases. Insolvency and Bankruptcy Fund. So this fund has been formed for the purpose of insolvency resolution, liquidation and bankruptcy of the persons under IBC. The source of fund is mainly the grant by the central government, amount deposited by the persons as contribution, amount received from other sources as fund, and the interest or other income which arises out of the investment. So a person who has contributed, they can actually withdraw the money from this fund, but it should not be more than what he or she has contributed or the organization has contributed, and the withdrawals can be for the payment to the workmen, for the protection of assets, uh, and for bearing the cost of the proceedings. Insolvency resolution process for companies and LLPs. So if the default is above 1 crore, the creditor may initiate insolvency resolution process. There are two stages which have been prescribed. One is insolvency resolution process and other is liquidation. In insolvency resolution process, the financial creditor assess whether the debtor business it is viable and whether they should continue the business, whether they should rescue the business or and restructure the business so that they can get their money back. And the second is liquidation. So if the insolvency resolution process, if this fails, then the if the insolvency resolution process fails or the financial creditor decides to wind up and distribute the assets to the debtor, then the then liquidation comes to place. Corporate insolvency resolution process, CIRP, if in short, it can be initiated by the financial creditors, by the operation creditors, or by the corporate debtors as well. So, who can initiate CIRP? This will be asked by you in your exam. So, it can be initiated by financial creditor, operation creditor, or the corporate debtor itself when a default is committed by the corporate debtor. So, it should be completed within 180 days. A CIRP shall be completed within 180 days from the date of admission of the application. And the adjudicating authority may provide an extension of 90 days. A one time extension it is there of 90 days uh, from the and the duration of CIRP, including the time for the legal proceeding, it shall not exceed 330 days from the insolvency commencement date. The committee of creditors should be appointed. They should appoint a resolution professional. So the committee of creditors is required to appoint a resolution professional, and it should be appointed within 7 days. The resolution professional prepares a information memorandum to resolution applicant. It submits the resolution plan to COC. The formulated resolution plan is submitted to COC for its examination, for its approval. Once it is approved, it is examined by adjudicating authority. So once it is approved, it is submitted to adjudicating authority and it is examined by the adjudicating authority. If it is in compliance, then the adjudicating authority issues the approval letter, and the RA should obtain necessary legal approvals, and it has to be done within 1 year of plan approval. Insolvency resolution process for companies and limited liability entities. Again, let's understand now the liquidation procedure. So let's talk about the liquidation process now. The adjudicating authority can order for liquidation of a corporate debtor if the resolution plan is not received, if the resolution plan is received but has been rejected for non-compliance, if the resolution professional informs about the decision of the committee of creditors to liquidate, or if the corporate debtor has contravened the resolution plan, in that particular scenarios, the adjudicating authority can order for the liquidation. And the adjudicating authority issues an order for liquidation, makes a public announcement, and send the order to the authority with which the corporate debtor is registered. On passing an order for liquidation, the resolution professional, on submission of a written consent of the adjudicating authority, uh, they act as the liquidator. So the RP is now the liquidator, obviously after the consent of adjudicating authority. So let's understand the liquidation procedure. So the liquidator forms an estate of the asset. So basically the list of the asset of the corporate debtor from which we can extract our money. So it is known as the liquidation estate, and it is hold in fiduciary capacity. After listing all the assets, the liquidator collects the claim of creditors, and this exercise is done within 30 days from the date of commencement of the liquidation process. The liquidator then apply to the adjudicating authority for any avoidance of any kind of preferential transactions. So they apply to the adjudicating authority. For companies, it is NCLT. Then the liquidator apply for the avoidance of undervalued transaction. So then there is an avoidance of undervalued transaction, and if the adjudicating authority is satisfied that the undervalued transaction were deliberately entered into by the corporate debtor for defrauding the creditors, then it may restore the position as it existed before. So if defrauding is the motive, then the restoration is possible by the adjudicating authority. And if a corporate debtor is a party to the externate credit transaction, uh, then the receipt of financial or operational debt during the period within 2 years has to be submitted, and the resolution professional may apply for the avoidance. The secured creditors can either relinquish the security interest or they realize it in the specified manner. Then there is a distribution of the assets. The proceed from the sales of liquidation, they shall be distributed in a specified manner in order of priority, and the dissolution is Now complete the liquidator. After all assets of the corporate debtor are fully liquidated, they will apply to the adjudicating authority for the dissolution. The corporate debtor is dissolved now on the order of adjudicating authority, and the copy of the order is provided within the next 7 days. Fast track insolvency resolution professional. This is in respect of corporate debtor. If in case there is an application for the fast track insolvency resolution professionals profession, if there's a so IBC has provided a fast track insolvency resolution process in respect of corporate debtor. This is basically in case the application is provided for fast track corporate insolvency process, and this can be in respect of a corporate debtor who is below a level which is notified, or he belongs to a notified class. The time limit is to complete the FIRP is 90 days, and extension of 45 days can be provided. This is the extension period, not more than that. So a creditor or the corporate debtor can file for application for fast track insolvency process, and the process of CIRP is the same for FIRP as well. Pre-packaged insolvency resolution process, it is mainly for micro, small and medium enterprises. The corporate debtor shall obtain an approval from its financial creditors representing not less than 66% of the value. The resolution plan has to be submitted within 90 days, and this process must be completed within 120 days from the date of commencement. A declaration is provided, so the adjudicating authority declares the moratorium, appoints a resolution professional, makes a public announcement, and the moratorium duration is again provided on the order. The corporate debtor then the list of claims is provided. Preliminary information of memorandum is provided. The corporate debtor within 2 days of commencement submits the RP about the list of claims, about the preliminary information memorandum. The management shall continue with the board of directors or the partners. Within the next 7 days of commencement, the RP shall constitute a committee of creditors, and this committee of creditors may resolve to initiate CIRP after this pre-packaged insolvency resolution plan commences, but before resolution approval. Voluntary liquidation of corporate persons. So a corporate person may initiate voluntary liquidation proceeding that should meet again certain conditions, certain procedures, procedural requirements are there. So the provisions related to the liquidation process shall apply to the voluntary liquidation proceedings. If any person initiates pre-packaged insolvency resolution process uh, or with the intent to defraud any person, then they will be penalized. The penalty shall not be less than 1 lakh rupees, but it may extend to 1 crore of rupees. Insolvency resolution and bankruptcy for individuals and partnership firms. So it applies where the amount is more than 1000 rupees. The amount should not be less than 1000 rupees. And our resolution professional is appointed by the adjudicating authority upon receiving the application. So who is the adjudicating authority in this case? DRT is the adjudicating authority. The moratorium uh, on all debts begin upon admission, and it lasts until 180 days. So 180 days period is provided. Then the creditors, if they have any objection, it can be raised within 10 days regarding any inclusion of debt, or if any details are missing, within 10 days uh, they can raise an objection. Insolvency resolution process. So an application is initiated. This application can be initiated by the debtor or by the creditor. There is an interim moratorium which is provided on filing the application. The insolvency resolution process provides an interim moratorium in relation to all debts, and it ceases on the date of admission of such application. The appointment of RP is done by the AA, meaning to say the adjudicating authority. The RP, resolution professional, within 10 days of his appointment submits a report recommending the approval or the rejection. Moratorium, it commences upon admission for 180 days. Public notice is provided, uh, inviting claims within 7 days, and the claims must be submitted within 21 days. The claim registration is there, so the creditors register the claims with the resolution professional. Repayment plan. So, with the help of the resolution professional, the debtor shall prepare a repayment plan containing the proposal to the creditors for restructuring his debts or his affairs. There is a meeting of creditors for repayment plan. Order of adjudicating authority is provided. The AA approves or rejects the repayment plan on the basis of the report of the meetings of the creditor, which is submitted by the RP. Then there is an implementation and supervision of the repayment plan. And finally, on basis of repayment plan, the resolution professional shall apply to the adjudicated authority for discharge orders in relation to the debt which is mentioned in the repayment plan, and the adjudicating authority passes such discharge orders. Bankruptcy order for individuals and partnership firms. So, an application for bankruptcy of a debtor may be made by a creditor, which is individually or jointly with other creditors, or by a debtor to the adjudicating authority, and this must be done within 3 months of the order which is passed by the A. When the application is filed, an interim moratorium period commences, and the adjudicating authority appoints the bankruptcy trustee uh, or nominated, which is confirmed or nominated by the board. The AA passes the bankruptcy order. He passes it within 14 days of receiving the confirmation or nomination of the bankruptcy trustee boards. Administration and uh, distribution of estate of the bankrupt. So, the bankrupt's affair are basically first investigated. What are the affairs of the bankrupt? How things are going on? Then the estate list is realized. It must be assisted by the trustee, and they follows the prescribed duties. The bankruptcy trustee then, while discharging his function, sells any part of the estate, but the receipt must be provided. It must be given to prove any claim and to arrive at dividend in respect of such dues. The bankruptcy trustee may, with the approval of COC, they can carry on the business of the bankrupt as well. A specific uh, the specified debts are paid first. Basically, in priority, they are paid, and the surplus applies to the interest and partnership debts proportionately. If there is any appeal, it can be filed to uh, DRAT within 30 days. So, from DRT, the appeals can be filed to DRAT, and from DRAT, the appeals can be filed to the Supreme Court within 45 days. So, from DRAT order, it goes to Supreme Court within 45 days. And if a debtor or creditor provides information which is materially false to the RP, then this is a punishable offence, and the fine can goes up to 5 lakh rupees, or imprisonment, or both. So, imprisonment can be of 1 year, fine can be up to 5 lakhs, or both can be awarded. Let's understand Legal Service Authorities Act. This act was mainly constituted to provide legal services at free of cost to the weaker section of the society, to provide the competent legal services, free legal services to the weaker section of the society, to ensure that there is an opportunity for securing justice. It is not denied only because they are economically weak, or for other disabilities. And this Legal Service Authority Act, under this Legal Service Authorities Act, Lok Adalats are organized. So, they are organized by state authorities, district authorities, Supreme Court legal service committees, High Court legal service committees, Taluk legal service committees. So these Lok Adalats are organized by these different um, committees. A Lok Adalat can compromise or can settle between the parties to a dispute, but again these disputes are this should be of non-compoundable, they should be of compoundable offences. They cannot handle non-compoundable offences. Non-compoundable offences are one which cannot be collated together, like murder, like robbery, dacoity. They are non-compoundable offences, right? Petty theft, it is a compoundable offense. So if the offences are non-compoundable, they cannot be entertained by the Lok Adalats. There is a monetary ceiling with respect to civil disputes that can be settled. So up to 20 lakh rupees civil disputes can be settled by the Lok Adalats. Keep that in mind. This figure is important for you. The award which is provided by the Lok Adalats, it is deemed as a civil court decree. Any court fees, if provided, and then the matter has been referred to the Lok Adalat. If the matter has been settled, then the court fees is refunded. And if the parties are the parties have approached to the Lok Adalats, and an award has been uh, provided, then that award will be binding and non-appealable, because it is provided by an amicable settlement between the parties. It is provided by the consensus of the parties, and that's why this award will be non-appealable in any court of law. Law of limitation, the last law of the class. So the Limitation Act has a significant application with respect to suits, appeals, applications, and all legal actions can be taken within this provided period. So the period of limitation is always in relation to a document which entitles the beneficiary to take an action in the court of law. It means the period prescribed for any suit or appeal or application by the schedule which has been provided under law of limitation itself. The prescribed period means the period of limitation computed in accordance with the provision of the Limitation Act of 1963. So a suit must be instituted, the appeal should be preferred, and the application should be made within this prescribed period only. If not, then the suit, the appeal, the application will not be entertained in the court of law. There are certain things which we have to keep in mind, that the suit should be instituted in, in the proper court to the proper officer, and when the court is closed, then the application can be instituted when the court reopens. So that particular day when the court is closed, it can be excluded from the computation of the period of limitation. Any application or appeal other than execution petition may be admitted after the prescribed period if the applicant can show cause that there's a reasonable excuse for not submitting the application within time. For example, he has met with an accident, he was hospitalized, and that's why he cannot uh, bring his application to the court. And in that scenarios, the court can excuse the delay. There are certain exclusions which are not considered while computing the period of limitation. So it excludes the day from which the period is reckoned, the first day. It excludes the day of judgment, the time which is required to obtain the copy. Uh, if there is any injunction provided, so during the stage of injunction, it excludes the time for obtaining government consent, government sanction, and if the defendant is absent from India or central government territories, then that particular time period is also excluded from the computation. The fresh period of limitation arises if when the period of limitation is subsisting, any payment has been made, or the acknowledgement of debt is made in writing, which is signed before the before the prescribed period, then in that case a fresh period of limitation is there. So this is the schedule. So there's a description of suit, the period of limitation, and the time from which this period begins. You only have to just read it once. No need to thoroughly memorize it. So when you see, you will see a general pattern that most of these cases, the description, the period of limitation is 3 years. For immovable property, always remember that the period of limitation will be more. So it is 12 years, 30 years, 12 years. For foreclosure, it is 30 years. For possession of immovable property, it is 12 years. To enforce payment of money secured by mortgage, it is 12 years. Again, you will see this pattern: any suit by or on behalf of the central government or state government, 3 years. Where there is no limitation period, it is 30 years. For execution of decree, it is 12 years. For recovery of loss by fraud, 3 years again. Appeal, for appeal, period of limitation is less. Uh, Always it is less. So for filing appeal to High Court, it is 90 days, and to any lower court, it is 30 days. So now let's check your progress. Debt recovery tribunal consists of a bench of 3 person. No, it is consist of only 1 person. So this particular statement is false. For recovery, the recovery officer can adopt the same method as adopted by recovery of income tax under the Income Tax Act. So this statement is true. Doctrine of election will come into play when there exists two or more remedies, when there is an inconsistency between the remedies, when there is a choice available. So all of these are correct. So when all the aforesaid elements are present, then the doctrine of election will come into play. So D is the correct answer. The period stipulated in the act for filing detail of security interest with central registry, it is 30, 15, 45. Actually it is none of the above. Have we discussed about any period? No. So it is none of the above in this case. Are hire purchase and lease contract covered under SARFAESI Act? So yes, they are covered under SARFAESI Act. So yes, yes is the correct answer. Provision of SARFAESI Act are applicable to pledge goods only, mortgage properties, securities that are not otherwise charged to the creditor, security charged to creditor not in possession of creditor. So D is the correct answer for this question. Who is insolvency professional? A qualified company secretary, a person who holds a professional qualification, an eligible person who enrolled with insolvency professional agency as its member, an eligible person who is registered with IBBI and enrolled with IPA. So D is the appropriate uh, option for this question. So D is the correct answer. To whom shall the provision of IBC apply? To corporate? Yes. Other limited liability entities? Yes. Personal guarantors to corporate data? Yes. Individual partnership firm? Yes. So D is the correct answer for this question. Lok Adalats are organized under Lok Adalats Acts. No, it is organized under Legal Service Authority Act, not Lok Adalat Act. So this is false. In Limitation Act, the definition of suit does not include uh, appeal or application. So yes, this statement is actually true. It does not include an appeal or application. So this statement is true. Now let's do some practice questions. We'll follow our elimination method. So which of the following combination of statement is correct with respect to Recovery of Debt and Bankruptcy Act 1993 as amended? Applies to all cooperative banks irrespective of their structure. This is false. So A is eliminated. Applies to multi-state cooperative banks only, not to all cooperative banks. Bank can file application only if the debt due is more than 10 lakh. It is 20 lakh, not 10 lakhs, and hence this is not correct. So we can eliminate B as well. 6 is common. Let's read statement number 4 and we'll get our answer. A recovery officer is responsible for implementing the recovery order of the tribunal and is appointed under section 7(1) of the DRT Act. So this statement is correct and hence C is the correct answer for this question. Which of the following statements are correct regarding the establishment, jurisdiction and authority of DRT and DRAT? Central government has the power to establish DRT and determine the areas within which it may exercise its jurisdiction. So this is correct. So we can eliminate A and we can we can eliminate B and we can eliminate option number D. So A and C remains. Let's read step number 2 and get our answer. Presiding officer of DRT holds office for a term of 10 years. No, it is 5 years or until the age of 65 years. Hence, this is not correct. And we get our answer. A is our correct answer for this question. In context of DRT, which of the following statements are correct? The appeal must be filed within 30 days from the date of from the date the copy of order is received. So this statement is correct. So we can eliminate option number C. The appellant is required to deposit 75%. No, it is required to deposit 50%. So 2 is not correct. Hence B is eliminated. An appeal can be filed against order passed by the appellate a tribunal. So the jurisdiction is provided under 226. SLP can be filed, but there is no provision of appeal from the order of DRAT. So this statement is not correct, and hence we get our answer. A is the correct answer for this question. Consider the following statement regarding the recovery process. The recovery officer can attach and sell both movable and immovable property. This is correct. So D gets eliminated. The defendant can dispute the amount specified before the recovery officer. No, this is not correct, and hence we can eliminate option number B. 3 is there in both A and C, so no need to read 3. Let's read statement number 4. The defendant must make a down payment of at least 50%. No, it is not 50%, but 25% of of the amount specified in recovery certificate to receive the receive time for the payment. It is actually 25%. Is when we say down payment, it is 25%. So 4 is correct, and hence sorry, 4 is not correct. This is what we are stating is 25%. So 4 is not correct, and hence C is the correct answer for this question. Which of the following statement about SARFACI are correct? Empowers bank and financial institution to enforce securities without the intervention of civil courts or DRT. So this statement is correct. C gets eliminated. The act applies only to loans secured with immovable property and excludes movable property. This is not correct, and hence we can eliminate option number D. The act applies to financial institutions whose names are notified by the central government but not to housing finance companies. It is also applicable on the housing finance companies. They are included, and hence this statement is not correct. Uh, 3 is not correct. So we get our answer. A is the correct answer for this question. Which of the following combination of statements are not correct based on definition provided in SARFACI? A financial lease ensures the lessee obtains ownership of the leased asset at the end of the lease term or upon the payment of a predetermined residual amount, irrespective of whether the lessee fully utilized the asset during the lease period. So the statement is not correct. Uh, so 1 is not correct. It is asking for not correct statements, so we can eliminate option number C. So 1 is there, 1 is there, 1 is there. So let's see statement 2. Hypothecation can be created on future movable property and restricted to cases where the borrower retains possession of the collateral throughout the term. So it can be created for future movable properties, but only for future movable properties. So this statement is not correct. Hence we can eliminate option number B as well. because we are looking for incorrect statements, right? A negotiable document is restricted to warehouse receipt and bill of lading with no other instrument qualifying under the law. So, negotiable documents are broader, not just warehouse receipt or bill of lading. Hence, this statement is not correct, and you get our answer. D is the correct answer for this question because it has all the elements 1, 2, and 3, and 5 and 6 will be correct because no other answer, no other option states 1, 2, 3 as well. So, which of the following statement about ARC are correct? Must have net